CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that morning. They don't talk to me. That morning. They don't talk to me. That morning. They don't talk to me. That morning.
What specifically is a mechanically propelled vehicle? So that's that question. We're asking them, do they know, in legal terms, what a mechanically propelled vehicle is defined as?
And I think, just to interject for a second, for anybody who's listening who might think, well, why are you asking such obvious questions? It makes complete sense to do so, because that's how the information is disseminated, and that's how you critically analyse what's actually been said to you and what you are accused with. So you don't gloss over what appears on the surface to be something superficial, because quite often, and that term mechanically propelled vehicle, which most of us would assume on first glance, oh well, that's just a car or whatever I drive, it may not necessarily be the case. So that's why with the letter we're actually going through pretty much everything they've said, and we're critically analysing it in an upfront and open way in front of them.
Correct, absolutely, yeah. That's the key word, critical. Critically, you have to critically. It's not being you're not criticising. And people often confuse the two. Criticism is a completely different thing. Being critical means you're analysing it. You're taking it apart. You're trying to get an understanding, a knowledge behind what's behind it.
Yeah.
So the next question would be, or is, how in law is said alleged mechanically propelled vehicle defined? So we're asking them what they know of its definition in terms of the law.
Yeah.
So we want them to tell us, how do they define it in law? Now, if they're using the term mechanically propelled vehicle, which they have, they should know what they're talking about.
Of course, yeah.
They should know the law. The next question is, what specifically is an alleged offence? So we want them to come back now and say, well, if something is alleged, what does that mean? So our research tells us that if something is alleged, it's unproven. So there has not been a court case. This is what it alludes to.
Yeah.
We know that, but we want them to tell us, well, how do you define the word alleged offence? So that's fine. Then the next question is, what specific alleged following offence are ye alleging was committed? So we want them to tell us again what they think the alleged offence was. It's not that clear as to what the alleged offence was. So again, we want them to tell us what law they're relying upon in that context. The next question is, what specific public place did said alleged following offence take place at? So now, this is a kind of a tricky question, and again, most people wouldn't be looking at this and say, well, a public place is a public place. Now,
Again, let's critically analyse it now and see what this is all about.
what is a public place? I mean, is the place the alleged offence happened at a public place, and how can they codify that? How can they prove that that's a public place? You know, what is a public place? The majority of the property, we'll say, for example, in Carlow or any of the towns really, it's owned privately in most cases.
Yeah.
So what are they defining as being a public place? We want to know, and we want them to prove that this is a public place. How are they going to prove it's a public place? So we want them to define a public place and who owns this public place. Maybe the council do own it, but maybe it's not a public place. Maybe it is a private place.
Of course, and let's be sure about that, because if you can potentially unearth a chink in their armour, well, of course you're going to use it.
Absolutely. Now, again, this requires more research, and what I'd suggest to the listeners is every time you hear us throw up a key phrase, Google it.
Yeah.
Or go to get a legal definition of it, or bring it out in terms of the acts and the codes and statutes. Now, the next question here, question H. What specific law and specific evidence are you relying upon in relation to your said claim alleged following offences? So we're asking now for the evidence they're relying upon. We want to know the evidence. Maybe they have CCTV footage, maybe they have photographs, maybe they have a picture of this woman getting in and out of a mechanically propelled vehicle in a public place. We don't know. We want to know in law what evidence they're going to rely upon.
And that makes sense. We've discussed that on previous shows as well, and it's always worth reiterating. unless you know specifically what you're accused of and why they are accusing you of that, it's very difficult to have any kind of defence to what they say, because you don't know what angle they're attacking you from. So that is very, very important, and that removes a lot of the fear. Once you do realise what's being used against you, well, you can address it then. It's very hard to address the unknown.
Again, going back to a point you made as well, Lionel, in some earlier episodes, how can you make a pleading? Because that's one thing a judge will say to you: how do you plead guilty or innocent? Well, how can you make a pleading when you don't know what evidence the other party have against you? What are you pleading against? You know, so that's a danger area for most people. If you plead if you plead guilty or not guilty, you're then given the court jurisdiction to make a decision, because you said, yeah, fair enough, I'll plead. That means I'm giving the court the ability to make the decision.
Yeah.
So again, it goes back to the pleading. If you do not have the evidence, how do you know what you're pleading to? It's not possible to make a pleading, although very often the court will try and push you into that arena of making a pleading. Very often people will go in and make an argument and say, well, it's wrong, it's this, it's that, it's the other. The simple question is, how do you plead? And the answer to that would be, if you do not have the evidence, how can I plead?
Yeah.
How can I legitimately make a plead? That's fine. Next question will be question I. Who specifically is the originator? In brackets, it's got traffic warden of said notice. So we're presuming at the moment that there was some form of a traffic warden. So I'll ask the question again: who specifically is the originator of the said notice? I.e., who was the traffic warden, if it was a traffic warden? So we want to know who has actually set this up, who set this case in motion, if you like. We're entitled to know that, because we may have to laterally cross-examine the traffic warden, and it's a position whereby I wouldn't have a problem doing it. I don't think you would have, given your experience, and I don't think most people should be afraid of this, because based upon our research to date, now there is exceptions to that rule. You might find a traffic warden or a Garda, for that matter, actually know the law. I'd be highly shocked by that.
Likewise.
So far, anyway. But then again, our experiences and observing what goes on in the courts has taught us that most of them do not know the law.
Nor do most of them care.
Correct. That's the worst part about it. Yeah, they're not concerned. Even though they have been caught out, they should then go and do a course. You know, even if it's only a certificate of some form or whatever it might be, and do a proper course on the law and learn it correctly. So we'll go on to the next question. Question J. Does the alleged traffic warden have hold? So we use the term alleged there, because we don't know if there was a traffic warden involved in this. So does the alleged traffic warden have hold legal qualifications, and or is the said traffic warden a legally practicing solicitor? So again, we're telling them up front, we want to know, is this traffic warden or this alleged traffic warden qualified in law to administer the law? What does he know or she know about the law? Again, it's a very simple question. I mean, I don't know how you couldn't answer that question, because you would know, if you are employing traffic wardens or as agents of the council or whatever it might be, you should know if they're legally qualified.
It's very simple. It's a yes or no.
Yeah. And I wouldn't imagine that most of them are. Maybe some of them are. There might be exceptions. Again, I'm not saying there isn't. But I wouldn't imagine you'd be a traffic warden if you're legally qualified in the law. I'd imagine you'd want some other form of administration.
Probably not, because most people do their jobs for remuneration, and potentially if you are qualified in the law, you could be far better remunerated.
Correct, yeah. Okay. Now, the next question would be question K. We demand stroke direct. Now, we're giving them an instruction now. We're telling them, you do this now, and we know we have the right to tell you to do this. So we demand direct that you provide evidence of said legal qualifications of said purported traffic warden, and or provide details of their said mandatory professional indemnity insurance details cover, if they purport to be a legally practicing solicitor. So again, it goes back to old stuff we've been doing, basic stuff. If they're a legally practicing solicitor, they have to have professional indemnity insurance. It's mandatory. It's called mandatory professional indemnity insurance, and anybody can look that up on the Law Society of Ireland's website. And we're not promoting the Law Society of Ireland's website, but it's there in black and white if anybody needs to look at it. And again, for those legally practicing solicitors, inverted commas, they will and are listed with the Law Society of Ireland, and you can look up the names of their insurers, which I think we discussed before. Now, the next question is question L we're on. Or is the said traffic warden not legally qualified and or insured, wherein he/she is purposefully and willfully misrepresenting themselves and acting out of office, wherein they, in law, can be found personally liable for making false allegations and issuing unlawful illegal notices, fines, etc.
Okay, take us through that one because it's multifaceted, if you like.
Okay, I'll read it again and we'll break it down as we go. Or is the said alleged traffic warden not legally qualified? So we're asking, is the traffic warden qualified in law or not?
Yeah.
Okay, and are insured. So if they're insured, grand. You tell us that, we'll want to talk to their insurers. Wherein he or she is purposely and willfully misrepresenting themselves. So we want to know, are they misrepresenting themselves as knowing about the law? Because you shouldn't be administering the law if you don't know the law.
And just to backtrack a little bit, why would we want to talk to their insurers potentially?
Well, you see, if there's a potential case whereby you could have a counterclaim against the legally qualified professional, whoever it might be, they're obliged, or it's mandatory for them to inform their insurers that there is a potential risk here or a potential case pending.
Okay.
So when you ask for those details, they have to inform their insurers. But obviously, I would suspect they're not legally qualified and therefore don't have the insurance.
Yeah.
But in terms of legally practicing solicitors, we call them, once you ask for their details as well, they have to inform their insurance company that they have been asked for these details and there could be a potential suit here, counterclaim or claim. So that then increases their risk. So their premiums potentially can go up the next year.
Okay, so they're not going to like that question being asked.
Definitely not. Well, certainly an issue like this will probably go to the legal department if they have a legal department in the council, and this question will be put to them, or it'll be put to them, because if the traffic warden, I'll read the rest of this sentence just to put it into context. So, or is the said alleged traffic warden not legally qualified and or insured, wherein he/she is purposely and willfully misrepresenting themselves and acting out of office? So if they're using the law and they're not using it correctly, they're then acting out of the limitations their office has.
Yeah.
So they're acting on their own behalf. So that makes them potentially personally liable.
Which is even more serious.
Correct, because if you bring a case against them in their personal capacity, then the damages they will have to personally take on.
Yeah.
So potentially it could be a risk to their livelihood anyway, but potentially any assets they might have or hold, which they don't want. Obviously they want the liability. It's called vicarious liability, whereby they're acting within their position on behalf of, say, the council, and the liability then is with the council. So that's vicarious liability. The liability isn't a personal thing. But what we're saying here is, if they're acting out of office, they're not acting on behalf of the council anymore. They're acting in a personal capacity, so therefore they can be sued in a personal capacity.
And that's pretty serious because they don't have that uniform to hide behind anymore.
Correct. Absolutely correct. So it is a deep question, and this letter, we'll say, should be brought to the attention now. The council themselves have a duty of care to the traffic warden to bring this to the attention of the actual traffic warden themselves because of this. There's potential liability there. So next question M, notwithstanding the burden of proof. So notwithstanding is, we're saying here, not forgetting.
Yeah,
We're not leaving it out. So I often get confused about that word myself, but I have to keep reminding myself, notwithstanding means that you're not forgetting about the previous stuff or something else.
Okay.
So notwithstanding that the burden of proof in law, as we've discussed in all other programs as well, is always on the accuser. So again, very clearly, we're saying here, we know the burden of proof is with the council. You have to prove your case. We can stand there all day and say, well, you prove your case.
Yeah.
And we don't have to say anything else. You bring the proof. We can look at this then, perhaps make a pleading. So the burden of proof is always on the accuser. Failure to fully disclose whatever evidence that you may purport to rely upon in relation to your said spurious allegations is deemed in law that you are willfully withholding, stifling and or suppressing evidence. So again, that's a meaty statement there. The key one there is, you are willfully withholding, stifling and or suppressing evidence, which, as you are fully aware, is constituted as a criminal offence. You cannot in law withhold, stifle or suppress evidence.
Yeah.
So whatever evidence they're purporting to rely upon or alluding to rely upon, they have to fully disclose it.
And if they weren't aware of that, you've now put it on the record, so they are now aware of it.
Absolutely.
And the onus is on them to research it, and I mean, they will uncover that is the case. So there's no excuse now. They can't hide behind that anymore.
Well, it would have been a fair assumption to make that they should already know this. And
you would think so, yeah.
Yeah, it would be. But just for absolute clarity, as you suggest, Lionel, we're saying to them here, look, we know that you should know this stuff. And you should be fully aware. But we're taking it for granted. We said, which as you are fully aware. So they better now go and make sure they're 100% on this.
Yeah.
In terms of, right, if we don't disclose the said alleged evidence against this party or the accused, then that's a criminal offence.
Okay.
If they have any evidence. Okay, which is fair enough. So, you know, all we're saying is give us the evidence if you have any. Well, that covers, I suppose, the main portion. As I said, it's only a sentence they have, one paragraph, so that covers in some depth some of the material contained within their material. So you're addressing their notice.
And again, there's nothing spurious in there. Fine, there is a lot of questioning has been extracted from what they initially said, but it's all relevant, it's all pertinent, and that's kind of the stage that most of us want to get to when we are critically analysing the letters and notices that we receive.
Now, having said that as well, this letter took like 2-3 days of toing and froing and questioning and trying to bring the lady up to scratch, because again there was a lot of fear involved in, you know, should I, shouldn't I. So eventually she did send the letter off. So we'll finish it off. There's only 2 more main points. Point 2 is, take note, isn't it true that under the Bill of Rights Act 1688 that all grants and promises of fines and forfeitures are of particular persons before conviction are illegal and void? Again, we discussed this before. Wherein are ye promising to unlawfully issue a fine before a conviction?
Yeah.
Very simple. You're trying to, and they've issued, right, we want payment, we want these monies. We have not convicted you. It's an alleged offence. We haven't proven it in court. So what we want now is to be paid for that, although we have not proven this in court. So that's a very straightforward question for them. But again, we're not assuming that they know this stuff. Although it would be fair to say we should be able to assume that, but, you know, history has taught us that.
Bitter experience. Yeah.
So the final point here in the letter is, finally, we demand and direct that you provide us with addresses and answers to all of the points and questions raised herein and in relation to your scurrilous allegations, and that you provide us with an attested copy, we'll explain that in 1 second, just take a note of that, Lionel, and of all alleged evidence in relation to your said allegations by return post. And we've said then, yes, by return post. Now the final phrase we have here is, just to remind them, and I think we should talk a couple of minutes about this as well, is ignorance of the law will not protect you. Conduct yourselves accordingly.
Important.
Okay. So the main points there, we raised that question of an attested copy. We were looking for attested copies of the alleged evidence that they're relying upon.
What's attested?
So that means that they'll have their paperwork, they'll have their evidence there, we'll assume for the moment. So the evidence needs to be original. The original evidence, i.e. the original ticket, the original this, the original CT, if they have anything.
Right.
So the originals have to be there. So then somebody goes in and photocopies or takes a digital copy of those items and will initial it to say that they have seen the original evidence. So you're not just getting photocopies, you're getting a copy that is attested by another party which needs to be identified.
Okay.
That they have seen the originals, that the original evidence does exist, and here's a copy of that, and that should be signed off, as in there should be a box with the signature on it and a date to say that they can attest. So then, if necessary, you can arrange to see the original evidence. Yeah,
I get you. Yeah.
So it's quite it's a phrase that I think needs to be put into more letters, attested copies. So you're allowing them to keep their originals and give you attested copies, signed copies that attest that there is original documents. Now, if those original documents don't exist and you go and try and view them, then they've created something.
Yeah, there's a problem there.
There's a problem there. So that's that. Then the other phrase that perhaps we should just discuss for a couple of minutes is, ignorance of the law will not protect you.
Yeah, because I've often heard it said, well, I didn't know that was the case, how can I be held accountable? But it doesn't really work like that, does it, Des?
No, it doesn't. You see, the term ignorance of the law will not protect you. And I don't remember the Latin term. It's probably a bit long.
Yeah.
You know, we did have it written down at one stage. But what it's saying is that anybody within the offices of, we'll say, the council, the law that they're alluding to applies to them. So their ignorance of their law that they're trying to use will not be put up with. They have to know the law. You know, that's what the phrase says. Your ignorance of your law that you're working under will not protect you. In other words, you could be deemed an unfit witness if you do not know the law that you're trying to impose upon people.
And that's not just you saying it, that's a legal maxim.
Correct.
Which means that that's an accepted term that is in use within the court system.
Correct. There is another legal maxim. Now, again, I cannot for the life of me remember the Latin term, but it goes something like, well, the law will protect the ignorant.
Is that not a contradiction?
It isn't a contradiction. Now, it's not often used, and certainly no solicitor will use it, nobody in the council will use it if you're going up against them. So what it's saying is the law will protect the people that are ignorant. So me and you, we're ignorant of the law. We're not alluding to be using the law to enforce it upon somebody else. We do not have to know the law.
Right, so it's all about the perspective, it's all about what side you're coming from, who initiates the action. So whether you're in a defensive position or an attacking position. In other words, if you're initiating some kind of action, you better know what it is that you're initiating. If you're defending, well then how can you be expected to know?
Correct.
So is that what you're saying? Yeah.
Absolutely. You have it off to a T. You said it better than I could ever say it.
Okay, great.
So that's basically the starting block for us. Obviously this lady is very, very concerned about what may or may not happen, and we can't give her any guarantees. Obviously we're just trying this. If you like, it's an experiment. If you like, a social experiment, we'll have a go. We might even do a bit of further depth research, so on and so forth, and find out some more information, and we'll happily, hopefully, conclude it with a positive outcome.
So at this point, that letter has been sent, so we're awaiting a response from that, and we will deal with that response on the show as soon as it arrives, pretty much.
Absolutely.
Great stuff. Well, I'm excited. I shouldn't be excited maybe, but I am excited to see what comes back, because some very pertinent and hard-hitting questions, but also simple questions that are answerable were asked. So it's going to be fascinating to see what they write back.
Just for the listeners, Lionel, not to oversimplify this, because this letter took in the guts of 3 days of work to put it together. And again, look, we've even spotted some things in it we would, at this stage, given further thought, improve or change.
Sure.
So these letters, although it seems simple, it's only 2 pages in response to what they have, it does take a good body of work. And that's what we want to put that across clearly to the listeners, that we didn't just sit down and it didn't fall from the sky a bit like rain does.
If only.
So just be cognizant of that, listeners. You need to sit down, analyse this. Obviously use the shows as a template to look at and approach it. What we're talking about here is critical reasoning, critical thinking, really.
Yeah.
And it's not a difficult process to get into your head, but once you get into it, you can. The more work you put in, the more you get out of it.
And it's a self-propagating system as well. I mean, the more that you critically analyse, the easier it becomes, and again, the more in turn you will do. And at times you can tie your accuser, if you like, completely up in knots, because if they are not cognizant of the law, well, they're in a spot of bother then if you are. So, yeah, it's going to be interesting to see what comes back. I'm very much looking forward to it, and we'll take it from there. So, as always, Des, thank you very much for joining me.
Thanks, Lionel.
And we'll talk to everybody in the next episode.
CLS Talks.